Okay, so the recording has started. So welcome to the Immigration and Public Benefits virtual training for public benefits enrollment assisters. My name is Shannon Drake Burr, and I'm with the Collaboration on Immigrants and Public Benefits. So this morning we wanted to let you all know that these slides will be available after the presentation on coveringwisconsin.org/immigration. We are recording the presentation today, and we will make it available in the future. The Immigration and Public Benefits Screening Tool that we will be discussing today was distributed in advance to all attendees via email, and it's also available on the website. And we wanted to let you all know that we will be taking questions, and that's an important part of this training, but we'd like you to submit your questions in the chat box, and we'll pause twice during the learning event to answer questions. And so feel free to pop them in there as they come to you so that you don't lose or forget the question. And then we will be looking through them and paying attention to them and answering them at strategic points. So very quickly, I just wanted to review why we are here today, and we're here for a plethora of reasons. We've had lots of patients, consumers, and clients express fear and anxiety about using public benefits, and that means that enrollment assisters across Wisconsin are getting lots of questions. We want to help people make the best choices for themselves, and we need to learn how to do that, so that's what motivated us to put this learning session together. And also there are a lot of mixed messages about what to do, so it's quite confusing, and the answers you get will depend on who you ask. And there is a lot of written information out there, but we have found that it's confusing and hard to digest, so we've really tried to simplify. So that is what has brought us here today. So this is who we are. Like I shared before, I'm Shannon Drake Burr with the Wisconsin Primary Healthcare Association. My co-presenters will introduce themselves when they get to their sections, but you can see all our faces here and the organizations that we represent.
Awesome. My name is Mariah Hennon, and I work with Legal Action of Wisconsin and specifically with the Farm Worker Project. As Shannon mentioned, we have given a lot of thought to both the materials that we've developed as well as kind of grounding ourselves into some guiding principles, which we just briefly want to discuss today. You can see them up there on the PowerPoint, but I just want to briefly go through them. Our primary understanding is that we all come today with good intentions, and some of us may come with personal experiences with the immigration system and or the usage of public benefits, and those experiences are very valuable and important. And we also do recognize and respect the fear, confusion, and stress that some immigrants may be experiencing during this challenging time and in this challenging climate. And so with both of those in mind, we also just want to recognize that it is critical for clients or consumers to make the final decision on any issues regarding their usage or their family's usage of public benefits or their immigration process. And even if you personally might approach the decision differently. And thinking through that, we want to recognize that circumstances change, both family circumstances as well as the immigration context and the immigration system. Circumstances are changing and things can change very quickly. So a decision that's made today may be different or maybe potentially could be made differently in the future or come back or revisited again. And then our third guiding principle of the day is that our primary goal is to empower individuals to make an informed decision about using their public benefits. And that goes back to that clients and consumers are the folks making the final decision on any of these issues. And we're here to empower people with information and then allow them to decide what is best for them and their families. And then just a brief point that we wanted to mention is that if we're not attorneys, we're also not trying to give legal advice. And so that's a hard balance sometimes as we want to give people the most information. But again, we're trying to provide good information so that people can make informed decisions, and we're not trying to provide advice that we might not be able or the best people to give.
Okay, so this is our agenda for the 2 hours we have together. I forgot to say it in the introduction, but we are muting lines to control for noise. So if you have a question, you are going to have to put it in the chat, or if you're having any sort of issue, please put it in the chat in terms of sound or not hearing us, because we do have a lot of attendees on the call. So we hope to get through this all today, and we're going to set a somewhat aggressive pace in order to do it. All right, good morning, everyone. And if you, I'm trying to mute everyone's lines as well, but please mute your own line if you can, if possible, just because we are still getting a little bit of feedback on the recording. All right, so the next section, I'm Caroline Gomez-Tom. Many of you from Milwaukee are familiar with me. I'm the program manager of the Milwaukee Enrollment Network, as well as covering Wisconsin's Navigator program, and the chair of the Milwaukee Latino Health Coalition. And if you all participated in a webinar in March, I did discuss current benefits to the immigrant community as it pertains to eligibility around enrollment in health insurance. And so this is a little bit of an overview, but also going into the realm of other public benefits. So immigrant status and eligibility is defined in many ways depending on the different programs that are available to immigrants. And sometimes they're pretty general terms. WAYS benefits define them as U.S. citizens and qualifying immigrants, U.S. citizen or national, be lawfully present. And really, what does all of that mean? Most public benefits list folks who are eligible as U.S. citizens or qualifying immigrants. In Wisconsin, when we're talking about programs like food share or WIC or Medicaid, most commonly those statuses include folks who are actually born or naturalized as U.S. citizens, refugees and asylees, permanent residents, a lot of times having some kind of time period that they would have had to been in the country unless they were children or pregnant women. And then there's actually a larger list that is linkable in this slide. And then there's some programs that are not necessarily considered public benefits that might accept a larger list of acceptable immigration statuses or eligible immigration statuses. One big example that a lot of my enrollment assisters are used to or aware of is the health insurance marketplace through the Affordable Care Act. Through healthcare.gov, they actually accept most, if not all, statuses other than folks who are considered undocumented and people who are under the Deferred Action for Childhood Arrivals or DACA program. And really, as long as that the status is verifiable, most likely folks would qualify for programs like the marketplace. And the financial assistance in forms of tax credits and the cost sharing reductions or the lower cost for deductibles, co-payments, and co-insurance are not considered a public benefit. Community health centers and free clinics can also be a program that supports folks who are of different varying immigration statuses. Someone who is undocumented or a DACA or any other status can go to a community health center or free clinic regardless of status. And they do not need to share their immigration status or social security number to get sliding scale fees or that discount that's available at the various clinics. Some of the other programs that do cover folks that might not have eligible immigration status for some of the other programs that we mentioned include BadgerCare Plus prenatal. This is specific to women who are pregnant who do not qualify otherwise for another program like BadgerCare, regular BadgerCare, or Marketplace. And then there's emergency services, and those are for parent caretakers, adults older than 65, and children who are undocumented, who are experiencing an emergency. And those folks would need a doctor, some kind of written language that shows that they're having an emergency and how the length of the emergency will continue. And as many of us have worked with families, we know that not everyone may qualify for the same programs. Some folks might not be eligible for certain public benefits, whereas family members could be U.S. citizen or children are born in the U.S., so they're eligible for various programs that maybe their parents aren't eligible for. And so it's important to know essentially what every single person may or may not qualify for, and that's why this webinar, this discussion is even occurring. And as we know, if children are eligible for these various programs, parents do not have to provide their immigration status or social security number on an application if they themselves are not applying. It's very specific to those who are applying that have to verify their immigration status. And so children would have to provide that information, but parents would not if they are considered undocumented.
Yeah.
And just a reminder for everyone to please mute your line, as there's some folks that we're hearing.
Say cool, but he's a nice guy. He's just really mental health concerns.
Whoever is talking to Julie, could you please mute your line? Thank you. All right. And then one important slide is that both language from the Centers for Medicare and Medicaid Services that apply to the health insurance marketplace and other federal programs, and then the Wisconsin Department of Health Services, which service programs like Medicaid, food share.
You now are a new point person. Woohoo! Emily, we need help.
It's important to know that those programs, they will not require folks who are not applying to provide their social security number. Any information collected is only to determine eligibility of said program, and will only ask that information of the folks that are trying to get that service. All right, and then here I will send this next slide section over to Megan.
Good morning, everyone. My name is Megan Sprecher, and I'm the Immigration and Poverty Law Attorney at End Domestic Abuse, Wisconsin. So we're going to talk about the benefits, the proposed rule on public charge, and what's happening currently. So first, we just wanted to kind of clarify what is public charge, which is something that you're probably hearing a lot about. So public charge is where the federal government determines an immigrant likely to become primarily dependent on the government for basic needs. And if someone, this is really important because if someone is considered likely to become a public charge by either U.S. Citizenship and Immigration Services or the U.S. Department of State, this can impact their ability to get a visa to enter the United States or get their permanent residency, or what we often refer to as a green card. At the very beginning, I wanted to talk about who is exempt from public charge. So what types of statuses where it doesn't matter if someone is getting any type of benefit. And I did want to point out that for all of these statuses, this is not something that could be changed through the rulemaking process. This would be something that Congress would actually have to change. So people under the following statuses, use of public benefits will not impact their ability to get a green card. So if someone is a refugee or an asylee, if someone gains status through special immigrant juvenile status, which is the type of status for youth who have been adjudicated abused, neglected, or abandoned. For someone who has a U visa or a T visa, those people are victims of crime who have assisted in the investigation or the prosecution of the crime. People with an approved Violence Against Women Act self-petition, so domestic abuse survivors. And then people who have obtained relief under the Cuban Adjustment Act, the Nicaraguan and Central American Relief Act, often called NACARA, the Haitian Refugee Immigration Fairness Act, and then also folks who have a special immigrant visa status, who are Afghan or Iraqi nationals who have helped the U.S. So people with any of these types of statuses can use public benefits, and it will not impact their ability to get a green card based on that status. So we talk with the public charge, we talk a lot about federal means tested public benefits. There's not a statute, there's no federal statute defining what a federal means tested public benefit is, but a lot of agencies use the same definition, which is mandatory spending programs in which the eligibility for the program's benefit, the amount of such benefits, or both, are determined on the basis of income, resources, or financial need of the income of the individual household or family unit seeking the benefit. Before we actually start about talking about the proposed rule and the changes with the State Department, it's important that we talk a little bit about the difference between consular processing and adjustment of status. So consular processing is where someone obtains their green card or another visa, like a tourist visa or something like that, from outside of the U.S. through a U.S. consulate. So one example would be the U.S. Consulate General in Ciudad Juarez, Mexico. So that's where someone has to go for their interviews and, do the application process through a U.S. consulate abroad. Adjustment of status is where someone obtains a green card from within the United States through the U.S. Citizenship and Immigration Services. So for folks in Wisconsin, that generally means the USCIS field office in Milwaukee. It's kind of complicated when someone is able to adjust status versus consular process. So rest assured that that's not something that we're expecting you to know or to be able to tell people whether they would have to adjust status or consular process. But just know that it depends on a variety of things like whether they currently live in the United States, how they entered, who petitioned for them, when the petition was filed, their current status, and several other factors. So why are we talking about this? Why are we talking about consular processing versus adjustment of status? Currently, the public charge assessment looks different depending on whether you or your family member is consular processing versus adjusting status. So the current public charge rule for adjustment of status, and remember, adjustment of status is where you're getting your green card from within the United States, from a U.S. Citizenship and Immigration Services office. They look at what they call the totality of circumstances test. So that involves looking at someone's age, their health, their family status, assets, resources, financial status, education, and skills. Currently, under the public charge rule for adjustment of status, getting your green card from within the United States, if you're using W-2, cash assistance, SSI, supplemental security income, or you have long-term care institutionalization paid for by the government, those are the only benefits that would impact that public charge assessment. It's important to note that if somebody in your household, besides the immigrant who's trying to get their green card through adjustment of status, gets a cash benefit, and it's the family's only income, that could be considered making someone likely to become a public charge. So the most common example of that is where maybe a family's U.S. citizen child is getting SSI, and that's the family's only source of income. So other than that, they're only looking at benefits that the actual applicant for adjustment of status, getting the green card, is receiving. They also look at an affidavit of support. You may have heard of people talking about this. So for family-based petitions and several of the employment-based petitions, the sponsor, the petitioner, has to submit an affidavit of support pledging to financially support the immigrant if they should ever need it. If that sponsor doesn't have enough income or assets, a co-sponsor might be needed to submit an affidavit of support.
Okay, so Megan has been talking a little bit about the current public charge rules, and we're going to switch or go forward into talking a little bit about what was proposed and the changes that were proposed. So in October 2018, a new public charge rule was proposed by the Trump administration that would impact adjustment of status cases. And a couple of key points to remember at this time is that this rule was proposed, but it has not been finalized, and we are still waiting for the publication of the final rule. And we do not know if or when the rule will be finalized and in what form that final rule will be. So we don't know exactly what it's going to include. We just know what was included in the proposal. And if the rule is finalized, an individual will have 60 days to decide if they need to end their benefits.
Okay, so just elaborating on that proposed public charge rule for adjustment of status. So the things on this list are what were included in the proposed rule. So none of them are actually in effect. Like Mariah was saying, the rule has not been finalized. So under the proposed rule, it would make receipt of a broader list of public benefits would impact someone in terms of their public charge determination. Earning less than 125% of the federal poverty level would be a negative factor in the public charge determination. Being under 18 or over 62 would be a negative determination. Having certain health conditions, having limited English proficiency, less than high school education, or poor credit history would all be factors that would be viewed as negatively. So if someone had one of the factors on the list, it wouldn't necessarily mean that they were going to be determined likely to become a public charge, but it would be a negative factor. And the officer would look at the list here when determining if someone's likely to become a public charge. So now we're going to shift gears a little bit and talk about consular processing. So remember, consular processing is where someone is getting their green card or other visa, trying to get admitted to the United States from abroad, so from a U.S. consulate in somewhere like Ciudad Juarez, Mexico. For consular processing, there have been changes made to how officers and officials make a public charge determination. So for consular processing, officers and officials at embassies and consulates use something called the Foreign Affairs Manual to make decisions about granting visas or entry to the U.S. to people who are not U.S. citizens. So in January of 2018, a little over a year ago, the U.S. Department of State revised sections of this Foreign Affairs Manual dealing with public charge. So it made it more stringent in evaluating a sponsor or a co-sponsor's affidavit of support and that person's actual ability to sponsor the immigrant if that ever was necessary, or to support the immigrant if that ever was necessary. It talks about evaluating use of non-cash benefits by applicants, sponsors, and family members. Talks about, in certain situations, the immigrant needing to provide proof of medical insurance or ability to pay medical expenses, depending on certain health conditions. It talks about the need to show job skills, job history, and education in some situations. So these have taken effect. The consular processing changes to the Foreign Affairs Manual have taken effect. And what we've seen, the result is that visa denials based on public charge quadrupled from fiscal year 2017 to fiscal year 2018. Attorneys are reporting that there's increased scrutiny, in particular at the U.S. consulate in Ciudad Juarez, Mexico, which is significant for us here in Wisconsin because the largest percentage of our immigrant community is from Mexico, and Ciudad Juarez is where they would consular process to get their green card. We don't have data on whether the denials are because officers are really scrutinizing these affidavits of support and the sponsor or the co-sponsor's ability to actually financially support people, or whether it's public benefits use or other factors involved in the change in the Foreign Affairs Manual. We don't have data on that. We also don't have any data on how many of the public charge denials were overcome. So if someone is denied a visa entry to the United States based on public charge, they can potentially overcome that denial, but we don't have data on how many of those have been overcome or will be overcome. We did want to mention the public charge ground of deportability. A lot of folks are reporting concern over, fear of deportation, which is really understandable these days. The current public charge ground of deportability is very, very limited. It only applies when a non-citizen becomes a public charge within 5 years of their last entry, or admission to the United States, or when they got their green card. It has to be due to a pre-existing condition. So like someone who gets their green card and then is in a work accident after the fact, that would not be considered a pre-existing condition. The pre-existing condition would have to exist before the person's entry to the United States or admission as a permanent resident. The benefit program that they're receiving must allow the state or whatever public entity is granting the benefit, must allow them to sue the recipient or someone else, which is typically the sponsor, the person who sponsored the person. The state or the benefit granting agency has to demand repayment. They have to actually exercise that right. The immigrant has to refuse to pay for the cost demanded by the state or the benefit granting agency. So this is very limited. And typically states and other benefit granting agencies have not, even when they do have the right to sue for reimbursement, they typically have not exercised that right. I think sometimes it's not worth all of the trouble, and it actually ends up costing them more than what they would recoup. That's something that could change, but typically this has been very, very limited. Very few people are actually subject to the public charge ground of deportability. You may hear people reporting increased fear about this. Within the last week, there was a news story with information about a leaked draft of a proposed rule. So this rule would be from the U.S. Department of Justice, and they're reportedly preparing a proposed rule which would expand the public charge ground of deportability. At this point, it hasn't even been proposed yet. It's just a leaked draft of a proposed rule. If the U.S. Department of Justice does end up proposing a rule to expand the public charge ground of deportability, the public will have 60 days to comment, just like we had 60 days to comment on the other proposed rule on public charge. Commenting is really important, and that was a big part of the campaign against this public charge rule. The other rule got, I think, over 200,000 comments. Comments are really important because it is the way for the public to communicate to the federal government how these proposed rules would negatively impact the community. And they're also used by groups in lawsuits when they're challenging finalized rules. So the effect of all of this is that you all are seeing families unenrolling in benefits, not enrolling in benefits in the first place. There's a lot of confusion over the proposed rule for people that would govern people who are adjusting status versus, you know, the Foreign Affairs Manual changes for people who are consular processing. You're seeing people who are afraid of disclosing personal information because they're worried that that information is going to get to ICE and that it's going to result in their removal. A lot of families are making decisions about what to do about their benefits without knowing whether use of public benefits would impact their status or their family's status. So one of the things that we wanted to make sure that we included in this resource that we created and in this PowerPoint is talking about who has the expertise to help, who can help families in this situation. And one thing that's important to point out is that immigration attorneys who don't routinely work with low-income families might not be as familiar with public charge and may err on the side of caution. It's also, I think, important to point out that it's okay to get a second opinion. So the rules of professional conduct for attorneys here in Wisconsin provide that, you know, it's okay for someone to seek a second opinion, even if they're currently represented by an attorney. And it's also important to note that if someone does seek a second opinion, the person they consult with has to keep that confidential from even the first attorney about the consult, unless the client says it's okay to talk to the first attorney about it.
Okay, so we are at the point now where we're going to pause for questions. If you have a question, please put it in the chat box. We have one question thus far, and it's going back to the proposed public charge rule, which the question was, does that mean that Section 8 and other housing benefits would not be counted towards public charge? What about energy assistance and food share? So really quickly, I just want to reiterate that it's a proposed rule, so we don't have the final rule yet. So we could talk about what is in the proposal, but we decided with our time today that we weren't going to spend a lot of time talking about the details of the proposed rule. That proposed rule is widely available if you search for it using the internet. And you can read which public benefit programs were proposed to be included. And if and when we have a final public charge rule, we will certainly be reconvening and updating resources and communicating about what public benefit programs were actually included in that proposed rule.
Yeah, the only thing I think I would add to what Shannon said is that benefits like that can currently be considered when you're consular processing because of those changes to the Foreign Affairs Manual. So that's where the distinction between consular processing and adjustment of status is so important, because the changes to the Foreign Affairs Manual have taken effect, but the proposed rule on public charge that DHS, the Department of Homeland Security, U.S. Citizenship and Immigration Services submitted, that has not taken effect yet.
Okay, we did have a second question that was, could you please provide a list of individuals that won't be impacted when receiving government assistance? That list is in the slide deck. It is the slide who is exempt from public charge. And really quickly, we can review that. So when you get your slide deck, you will see it. And these are the people that if something was to change, it would have to be through an act of Congress, as Megan shared. So those are refugee or asylees, special immigrants with juvenile status, U or T visa holders, so those are victims of crime, Violence Against Women Act approved self-petitions, relief under the Cuban Adjustment Act, Nicaraguan and Central American Relief Act, Haitian Refugee Immigration Fairness Act, and special immigrant visa holders from Afghanistan and Iraq, or Afghani or Iraqi nationals who have helped the United States. Are there any other questions? If so, please put them in the chat. Okay, so we have another question, which is, would people who are currently going through the asylum process who have a work permit be affected?
So once someone has been granted asylum status, that's a type of status that does make someone eligible to apply for their green card. And asylum is on that list of statuses where it will not hurt the person's chance of getting a green card if they use any type of public benefit.
Any other questions or follow-up? Sorry, so they meant to clarify, do not yet have asylum status.
So it depends on how they are applying for their green card. So if they have a pending asylum claim and then they get asylum status and they're applying for their green card based on that asylum status, they are exempt from public charge, and it doesn't matter what kinds of benefits they've used. If they have a pending asylum status and it's denied, and then they adjust status or consular process through a family member, then we'd use this screening tool, which we'll get to determine if someone needs to talk to an attorney about public benefits use.
Thanks, Megan. So we have another question, and it is, will the children receiving public benefits affect parents wanting to become will affect the parents' immigration status? I think we'll pause on that question because we are getting to that, and we're getting to how do you screen and when do you refer people with these questions. So we're going to hold on that question, Lorna, and we're going to go forward with using the screening tool, and we will revisit it at the end and make sure that you have an understanding of what to do in that situation. So I'll hand it over to Stephanie.
Good morning. My name is Stephanie Sievers, and I'm the Health Insurance Literacy Lead at Covering Wisconsin. So in this section, we're going to talk about using the screening tool. So everyone should have received a link that takes them to the website or web page where they could either print or download the screening tool. It is called Immigration and Public Benefits in Wisconsin. And we will be updating this as we learn more or a new rule comes out with public charge. So we will continue to update this, and we'll always have a date of when the last one was updated. And we do have sort of an interactive portion on our web page there that goes through some of these screening questions. If you find that more interesting to use with clients, you're free to do so. Okay, so before using the screening tool, I just want to let's all remember to take a moment and put ourselves in other people's shoes. Anytime someone is in a stressful or fearful moment, they may, I should say, will likely struggle to understand policy and how it might affect them. So if you've received any training on health literacy, health insurance literacy, or trauma type trainings that really think about meeting people where they're at, those are the things we really want to put into effect as we're working with people over this really stressful moment and in people's lives. So some techniques to use when we're talking with people are to make sure we put policy into everyday language and we explain any jargon. For example, you might ask them about SSI. They may not know what that is, but if you say, it will appear on your statement as $83.35 payment for a single individual, that might jog their memory, and then they might say, oh, I do get that. So just remember to talk through things and use the language that people would actually use in those moments. We need to enunciate and go slowly, especially if someone's first language is not English. It's going to be an added barrier and layer that makes things more complicated to understand. People really need that we repeat and summarize as we go, so don't cover an hour's worth of information without pausing to repeat and summarize. Obviously, we can't do that in this training, but it's very good policy when you're explaining complex ideas. And then ask questions to check comprehension as you go. We call this often in healthcare settings teach back. It's truly a very, very important tool in your toolbox. Don't ask a yes or no question. Ask a specific question related to that person's needs and what they need to know. So when we work with people, we need to first validate their fear. As we all know, this is an extremely confusing time. There's a lot of news about changes to immigration, and a lot of people may not be getting accurate or up-to-date or information that is going to really help them, to empower them to make a choice. And so it is our role to provide them with as much accurate information as we can, and with those referrals to find out more. So by empowering people with knowledge, we need to communicate to the people who are not going to be impacted that they can use public benefits without a negative impact to their immigration status. And so the screening tool is going to help you identify who may want to talk to a lawyer before signing up or before ending their benefits, because we have heard a lot of people are coming in and asking for help to cancel or end their benefits. So I just want to say that even if someone screens, we're going to go through these questions, but even if they get a yes screening that maybe they should talk to a lawyer, it does not mean that using benefits will impact or harm their immigration status. It means they need to seek out more information. Okay, so first, now this is on the back side of the sheet. You really want to find out if they have one of these statuses that Megan was covering earlier, because these people will not be impacted directly by using public benefits. Now, there's a little red warning in the top right corner. Now, if they want to sponsor or co-sponsor a family member to come to the United States, then they will want to talk to a lawyer before using public benefits. Okay, so what we want to do is go through these questions. We have 3 primary questions. They're actually statements, but I like the word question better. And if you get any yes answer, that's where you're going to want to make a referral to a lawyer. And we'll talk about that process after we've talked about the screening tool. So the first question is, I or someone in my family will have to use a U.S. consulate outside of the U.S. to either apply for a green card, sponsor or co-sponsor an immigrant to get their green card, or apply for entry to the U.S. Now, if they have relatives who live outside the United States and they want to bring them here, they will definitely say yes to that question. If they have family members already here who they want to sponsor, it's unclear whether or not they'll have to use consular processing to do so. It depends, as Megan said, on how they enter, a variety of factors, including how they enter the United States. So in that case, if they are unsure and it's really important to them to bring that family member or change their status, then they should seek out some legal services before making a decision. So the second question is, I don't have a green card, but get one or more of these. Now, many of these things are complicated, and a lot of people may not know what they are, so be sure to explain clearly. So the first is Medicaid long-term care, and only if they have that program and it's paying for some type of facility, such as assisted living or a nursing home. If it's not paying for a facility, if it's just paying for in-home care, it doesn't count towards this. Cash benefits from W-2, so people might call that welfare, or it could be SSI, cash benefits from SSI. And again, a lot of people may not know if they're getting SSI, but they might recognize the amount on their bank statement. So that's $83.35 for one person and $132.05 for a married couple. So, and then lastly is someone in the household gets either W-2 or SSI, and there's no other income for the family. So if they answer yes to any of those, they're going to want to consult with a lawyer. The last question is, I have a green card and I plan to travel outside the US for more than 6 months. So what's important here is that any green card holder who leaves the country for more than 6 months will go through an outside consulate to re-enter. Is that correct, Megan?
No, so they could be assessed for public charge.
Okay.
So oftentimes that's actually through Customs and Border Patrol.
Okay.
So that would be at a port of entry. So either like at the border or at an airport.
Okay, great. And then, so the exception to that 6-month rule is any of the statuses we mentioned before that are the exception. Okay, and then Shannon's going to go over, if you get a yes answer, how you might refer someone to a lawyer and some important things to think about while doing so. And I'm trying to think if there's anything else on here. Oh, and for frequent updates, again, just go to the website. We even made a change this morning to the sheet. So always go to the website to check for new versions.
Thanks, Stephanie. That was great. Yeah, so Mariah and I will be talking about referring clients who need a lawyer or a BIA accredited representative to get advice on this situation. So there's kind of two types of people who are blessed by the law to give this kind of advice. So if anyone is in one of these situations, if they're confused about something an immigration attorney once told them, if they have doubts or further questions, if they don't know if they need to use a consular office to process, if they answered yes to a screening question, one of the screening questions we just reviewed, or if they don't know or understand their current status or a loved one's status, you should make a referral. So those are things that public benefits enrollment assisters, there's no expectation that you would be able to provide these answers. You shouldn't be providing these answers. These are people who should get some legal assistance and legal advice about their immigration questions. So one thing that was very important to us when telling you all that you should be making some legal referrals was to put some good legal referrals in front of you and make them as clear and accessible to you all to share with your patients, consumers, clients. So on the back of the sheet, we have a list of free services and a list of low-cost services. And we did do a lot of sleuthing and asking questions of these services. We didn't just, these aren't just the results of a Google search that we popped on to the sheet. We called, we validated, we had conversations with each of these organizations that they would be willing and able to provide advice on this particular situation. So on the intersection of immigration and public benefits, because this is a niche area. This isn't something, as we discussed before, that all immigration attorneys are equipped to answer or that all public benefits attorneys are equipped to answer. This is really an intersectional issue. And a lot of these organizations on this list, or all of these organizations on this list, these are the types of questions. This is their bread and butter. They understand the complexity of the issue, and they also have resources at their disposal. If they get a question that they don't answer, they know who to reach out to answer that question. So very quickly, on the free legal services, BadgerCare and Rise Law Center have specific eligibility criteria based on household income and immigration status. So when someone calls for advice, they'll first be screened to see if they meet the criteria. So we decided not to put the criteria on the sheet because, frankly, we didn't have space and it's complex. And the best thing, if somebody wants to use one of those two entities to get legal advice on their question, is to call and get screened. When you are presenting these as avenues for getting answers to questions, you can say, if you call and you're screened and you don't qualify, then go to these next providers of advice. So the Community Immigration Law Clinic, the International Institute of Wisconsin, the Sunshine Legal Clinic don't have eligibility criteria. So anyone can walk in and get some free legal advice. But it's important to note their capacity is limited to a few hours each week, and it's a first come, first served service. Here's a list of the low-cost services. So there are several legal service agencies in Wisconsin that provide low-cost consults. So we contacted each of these agencies to ensure that they're able and willing to address immigrants' questions about using public benefits. And I just wanted to note, we tried to be clear about what the cost for the initial consult would be. And I know that the Catholic Multicultural Center and Catholic Charities say 0 to 50, which is kind of confusing. What they shared with us is, their standard first consult is $50. They won't turn anyone away because of their inability to pay, so they might ask that they pay less, or they might waive the fee depending on the particulars of the situation. But the expectation is that there will be a fee involved, and they will say $50, and if the person says, oh wow, I can't, they will have a further conversation.
Okay, and so this is Mariah again, and I just wanted to mention another resource that is available for situations in which an immigrant or a family member of an immigrant does decide that using benefits is something that they want to do. However, if they, for example, if the immigrant or their child are using benefits but they have been denied and they don't understand why that happened or how to appeal the decision, Legal Action of Wisconsin is a resource for those folks. Those individuals could call the intake number, which is listed below, and say that they have an issue with public benefits and they would be able to receive assistance if they ended up being eligible. However, I did want to put also a note on here that for enrollment specialists or community partners or immigration attorneys who would like to learn more about immigrant eligibility for benefits based on the current rules, this is not a forward-looking consult, but for someone who has a question on the current rules, or again, if you're working with an immigrant who is experiencing issues with a denial, a reduction, termination, or accusations of fraud, overpayment, or another issue with their public benefits in Wisconsin, you are welcome to reach out directly to Pat DeLezio and Rhonda Van Penbrook, who both were willing to give their direct numbers to enrollment specialists and community partners to talk to them about issues that immigrants who decide to use benefits may be having. Okay, and so I want to talk a little bit too about some tips in how to make a good legal referral. And I think the first one is that when an individual is preparing to make a call to a legal provider or is trying to think through this process, it's really helpful if you as the enrollment specialist or as their advocate can help them identify what is their primary legal question. What are they really looking to answer, and what is their goal when they speak with an attorney? A lot of times when we're getting intakes, folks understandably have a lot of things that are going through their mind, but for us to most efficiently talk to that individual and give them the information that they need, it's really helpful if they can narrow down, like, what is my goal? What am I trying to get out of talking to this attorney at this moment? And again, a lot of the providers that we included on our list may be able to work on other immigration issues, but specifically they're listed on our list because they're able to provide information about the intersection of immigration and public benefits. The second tip that I would have for folks who are trying to refer individuals to legal assistance is to help them collect all the paperwork related to whatever their primary legal question is. So for folks with questions on immigration and public benefit, that could be any immigration applications that they've already filed or have started and are thinking of filing. That would be copies of any public benefit applications that they, again, have either filed or are thinking of filing. Records of public benefits that they've received. So how much or what type of public benefits, what were the dates or the years that they received those, how much were they receiving? And then any letters received from public benefits agencies. So really anything that's connected to their question is really helpful to have ready in one place and be able to give that to an attorney who's able to review those documents. The third thing is an individual with a legal question is going to have to complete an intake process for any of the legal organizations that they talk to. There will be some sort of process. It'll be different for each legal firm or organization, but questions can only be opened after speaking to the individual with the legal question or issue. So for example, if you're an enrollment specialist and you're working with an individual who has a question, it's really important. You might be able to help that individual call that organization, but the organization is going to need to speak with the individual who has the legal question. We can't open cases based on just enrollment assister's word, or that they're working with the client. We have to talk to the actual person. And exceptions can be made for minor children, and that's going to depend on each individual organization. The next tip would be to help an individual manage expectations of a referral. So it is, as Shannon was mentioning, it is kind of a niche legal field. So there are going to be immigration attorneys who don't necessarily have background in the public benefits, as well as public benefits attorneys who might not be as familiar with the immigration side. The organizations that we have highlighted have said that they have the capacity to take on that intersection, but it is really important to recognize that each organization will have their own guidelines and eligibility restrictions, and that an individual who's referred will have to work within those. It's also very unlikely that an individual will receive immediate advice for their question or their issue. And just to prepare people that a lot of times this legal consult is a process. And we wish it could go faster sometimes, but unfortunately it will take a little bit of time. And then don't make any promises about what an attorney can or cannot do. We really do want to, legal professionals really do want to help the person who's calling, but there might be limitations, and it's just easier if there are no expectations set beforehand. And then the final tip that we would have for making a good legal referral is that it's helpful to develop relationships with the referral or the referral agencies in your area. And that will allow you to have a better understanding of what the capacity might be to serve individuals, and it'll make the referral process easier for you as well as the individual in need of legal assistance. So there might be a better way to connect people. There might be times when you're able to, walk in with someone, and that's going to be based on the individual agency and your relationship with them. Oh yes, and then the last slide that we just wanted to let you know is we've been mentioning quite a bit the website for the Wisconsin Collaboration on Immigrant and Public Benefits, and so the website is listed there. We, as we mentioned, are unsure when or if the final rule may be released, but as soon as that is released or more information is made available about any of these topics, we will be updating the Wisconsin Collaboration on Immigrants and Public Benefits webpage. And then the second webpage we just wanted to mention is the Protecting Immigrant Families webpage. That's a national coalition of groups doing similar work, and they do have other resources available on their webpage. So these are both resources for you guys to use to keep checking for updates and documents and that sort of thing.
Thanks, Mariah. I also wanted to share that when you go on the website and you look at the legal referrals that are there, those are clickable links. So you can click that link, it'll take you to that law firm or that agency's website, and you can look at it with the consumer, client, patient in front of you, if that's helpful to you, if you want additional details. And I will hand it over to Carolyn.
All right, wonderful. So now I hope you have your guide on immigration and public benefits in Wisconsin sheet right in front of you, because we'll be going through some mock scenarios where I hope folks will be engaged in the chat box with some of the answers. So our first example, refugee or asylee, Javier, Miranda, and Josue are new arrivals to Wisconsin. They all have been granted asylee status. Javier finds a job, but it does not offer insurance. He is concerned what his family may qualify for, and if it will impact their ability to keep their asylee status and to eventually become citizens. So what are some of the first steps that you guys would do to work with Javier and his family?
We want you to, if you're able, to put some answers in the chat box so we can have kind of an interactive discussion of what a first step would be in this case. So we'll give you all a minute. Okay, so someone has said refugees are exempt. Other thoughts?
I believe in you all.
We know it's still morning, so we're going to take our time here. We're at 11 o'clock. We're doing well on time.
We have one other response. Their asylee status will not be affected if they receive benefits. Use the tool. I love that. Thanks, Kirk. Asylees can get health benefits through the marketplace.
You're all great, great comments. Keep them coming. Okay, so I think we can advance.
All right.
Okay, thanks everyone for participating. The first thing that I would look at on your sheet is that section on the back that talks about, do you have a status listed below? And that's where you're determining if someone has a status that makes them exempt from the public charge determination. So you'll see with the very first bullet point under that list is someone with asylum, like this family was granted asylum, they are exempt from the public charge assessment. So what that means is that, you know, after they've had their asylum status for a year and they're able to get their green cards, they will not be subject to a public charge determination. So receiving public benefits, any public benefits, will not hurt their chances of getting a green card. There is that red box, that kind of caution box that talks about, you know, if you're wanting to sponsor or co-sponsor an immigrant or petition for a family member, that would be a situation where you would want to talk to an attorney ahead of time. So for this family, receiving public benefits will not hurt their chances of getting a green card based on their asylum status. But if they're wanting to sponsor someone or co-sponsor someone or potentially petition for a family member, that would be a situation where they might want to contact someone on the referral list.
And based on eligibility for coverage, I see a couple people saying differing things in the chat box. But if they're of asylee status, they all could qualify for BadgerCare Plus, depending on income, which we're not getting into. But they also could be eligible for Marketplace if their income is higher above the BadgerCare limit. So now we'll go to the next example. Example, undocumented immigrant. Natasha is pregnant and is an undocumented immigrant. Please allow me to apologize for my cold. I'm not saying words properly. She goes into her local community health center for a doctor visit to confirm her pregnancy and is referred to the patient navigator to connect her to services for a healthy pregnancy, like WIC, BadgerCare, prenatal, etc.
So I guess what we're asking you to do here is imagine that you're that patient navigator and she comes to you and she says, you know, you're being queued up to sign her up for BadgerCare, but she says, oh, would that have any impact on my possible future ability to gain some sort of legal status here in the States? What would you do?
So we have Susanna saying it won't It won't affect her based on the current rule. It may affect her if it's her only source of income, says Helen. Any other thoughts?
And remember, we don't expect you to, or maybe we weren't clear, to project what the impact might be, but rather we're asking what would you do? How would you guide Natasha or help Natasha to make an informed choice?
So we have Laura saying refer her to one of the free legal services. Qualifies for public emergency assistance, question mark. Assist her in applying for NQIPW, non-qualified immigrant pregnant women. Is that right, Lorena? Make a referral to an attorney. She would be able to get BadgerCare Plus without repercussions. Lorena, yes, thank you for confirming.
So I'm going to push you all a little bit more. So she's come to you, you know, you're like, okay, let's get you signed up for BadgerCare. And she says, oh, but I'm concerned about the immigration implications that doing this might be. So how could you clarify whether she should be concerned or not about signing up for BadgerCare prenatal? What tool might you have?
So someone says she is at a community health center and will assist today with no issues she should worry about. And then someone says, Sandra says, look at the tool. And Helen says, I would tell her that it isn't a rule yet, only a draft. The screening tool states she doesn't have to provide her Social Security legal status. Nice, Susanna.
Any other thoughts? So where would you look, if you're going to look at the tool, which we all hope you are, where are you going to go to in the tool? What section? Top right, second page. Okay. Are you undocumented? All right. Where else do I need to talk to a lawyer? Okay. I don't have a green card, but, okay. All right. I think we can.
Oh my gosh.
Oh,
Sorry.
That's okay. So we're hoping that you go to the do I need to talk to a lawyer and go through all the screening questions.
Okay, so if I'm looking at that do I need to talk to a lawyer section on the first page of the tool, I'm going to go through the questions with the patient. The first question is, I or someone in my family will have to use a U.S. consulate outside the U.S., so remember that's consular processing, to apply for a green card, sponsor or co-sponsor an immigrant to get their green card, or apply for entry to the United States. So at this point, I think we just don't really know enough details about Natasha to know how she's going to answer that question. So it's really going to depend on her circumstances. She could be someone who is undocumented but married to a U.S. citizen or a green card holder. So she might answer yes to that question because she has a green card holder or a U.S. citizen family member who can petition for her, and she knows she's going to have to consular process or get her green card through a U.S. consulate outside of the United States. So she might say yes to that question based on a situation like that. And in that situation, if she says yes to that first question, then you would go down to the bottom left corner of that first page and talk to her about talking to an attorney before making any decisions and referring her to one of the places on the back of the sheet. She might say, no to that first question. She might know that she doesn't have any family members who can petition for her. You know, if someone has a U.S. citizen child, they can petition for their parent, but not until they turn 21 years of age. So she might say no to that question because she doesn't have a U.S. citizen child anywhere near age 21. So I think things to think about are, you know, letting them direct you. There could be situations where someone might answer yes or no. You know, someone might say if they're pregnant with a child and they know that child's going to be a U.S. citizen when they're born, they might say yes to that question because they're thinking of that child, you know, once they turn 21, they'll presumably be able to petition for that parent. So really letting the patient guide you. And then, like someone said in the chat box, reminding undocumented family members that they don't need to share their immigration status or a social security number. And some people might say, I don't know if I'm going to have to consular process or if I can adjust status. And that would be a situation where they could be referred to any of the providers on the back of the list for a legal assessment.
And I just want to remind everyone, as Megan shared, you know, let the person in front of you guide the conversation and make their own priorities. So she might say, you know, I don't know, and so you could say, okay, well, I can give you a referral to a legal organization to, you know, explore that question. And then she might say, okay, but you know, it's really important to me. I want BadgerCare prenatal, and if she's income eligible, then you know, proceed. She's stated her priority to you. You don't need to push back and say, but. As long as, you know, if she asked the question about immigration status and you talked to her about it and gave her the opportunity to, you know, give her a referral to a legal entity, and if she says, you know what, today I really just want to get signed up, sign her up.
All right, so the next section, next example, are permanent residents, green card holders. Pa and Vang are married and have been permanent residents for 12 years. Vang recently lost his job, and Pa decided to apply for food share to help with grocery bills while Vang searches for a new job. What would you guys consider for Pa and Vang?
So again, this is assuming they come to you for help applying with food share, and during that process, they raise the immigration issue and they say, oh, yeah, we want to apply, but would this have any, you know, status on our ability to become U.S. citizens in the future?
All right, so Susanna says they should not be affected as they have been legal residents for more than 5 years based on the current rule. Lori says, do they plan to travel outside the U.S. for more than 6 months? That's a good question. Helen says, refer to Q2 on do I need a lawyer? Kirk says, bring up travel.
Okay, great. So I think like you guys were saying, we just go through those same questions, and it's going to depend on Pa and Vang's circumstances, whether or not they're going to answer yes or no to these. So the first question, I or someone in my family will have to use a U.S. consulate outside the United States to apply for a green card, sponsor or co-sponsor an immigrant to get their green card, or apply for entry to the United States. So Pa and Vang might say, yes, we're planning on petitioning for our child. They might answer yes to that question. They might say, no, we're not, none of this applies to us. Question number 2 doesn't apply because they do have their green cards. But then going down to question number 3, like a few of you said, that's an important question. So they both have their green cards, and asking if they plan to travel outside the United States for more than 6 months. So Pa and Vang, with that question number 1 and question number 3, they might they might say yes, they might say no. It's really going to depend on their circumstances. If they say no to all the questions, then you would point them to the answer no to all 3 questions box, which talks about them being able to use benefits without affecting their status, but also noting that if the law changes, if the proposed rule is finalized, they would have 60 days to decide what to do. If they answer yes to 1 or more of the questions, then you would point them to the referral section. And I think a quick plug for naturalization. When people have had their green card for 5 years, they're eligible to naturalize or become U.S. citizens. There are a lot of resources available to help people with that process, and something that people are often scared about is the requirement to speak English, and there are exceptions to that. So in this situation, it would be wonderful if Pa and Vang were interested, if they would naturalize. There are also some situations where you can naturalize sooner than 5 years.
And Megan, I had one more question on that. Does using public benefits affect the naturalization process? If I'm applying for naturalization, is that something that's going to be considered?
No, it is not.
All right, so one of our last examples, mixed status family. So Gabriel is an uninsured 2-year-old U.S. citizen whose family uses sliding fee scale services at a local community health center. He was recently referred to a developmental pediatrician to address some developmental delays. Gabriel is eligible for BadgerCare Plus, but his mother Maria is reluctant to enroll Gabriel. Maria is DACA status, or Deferred Action for Childhood Arrivals, and hopes to obtain permanent residency in the future. She's heard that enrolling her kids in public benefit programs might make it difficult. However, Maria cannot afford the specialty care that Gabriel needs.
So again, I ask you to imagine that Maria and Gabrielle are in front of you, and Maria's saying, well, I want to enroll Gabrielle in BadgerCare Plus, and we're going to assume that their household is income eligible. Gabrielle is eligible to enroll in BadgerCare Plus. And Maria is saying, but I'm worried about the impact it might have on my immigration status, my ability to obtain permanent residency in the future. So how would you guide Maria on that question about the potential impact to her immigration status? What could you do?
So our first response is from Sandra. Gabriel is a citizen and his stuff doesn't affect Maria. Any other thoughts using the sheet? Susanna says she can apply for Gabriel, but not for herself. Helen says, even though G is 2, would it affect him sponsoring his mom in 19 years, question mark?
Okay, so let's go through those questions again for this family. So looking at question number 1, I or someone in my family will have to use a U.S. consulate outside the United States or consular processing to apply for a green card, sponsor or co-sponsor an immigrant to get their green card, or apply for entry to the United States. So that's really the big question for this family, and depending on their circumstances, they might answer yes or no to this question. So DACA is a type of status where you can't apply for your green card based on having DACA status. So says that Maria hopes to obtain permanent residency. She hopes to get her green card in the future. We don't know how she's planning to do that. So it could be, again, that she, has an option, like she's married to U.S. citizen or a green card holder, and it's something that she's expecting to happen sooner rather than later. It could be that she's thinking ahead to when Gabriel turns 21, and since he's a U.S. citizen, is able to petition for a parent. So we don't know how Maria is planning to obtain her green card status, and she might say, if it is that she's depending on Gabriel when he turns 21 petitioning for her, it's really going to be how she's going to decide, am I going to say yes to question 1 because of that, or am I going to say no to question 1 because, who knows what the law is going to be in 19 years. So it's really going to depend on Maria and her circumstances, whether she answers yes or no to that question.
And I think we want you all to be thinking about, it might be a situation where you do the screening questions with Maria and she talks to an attorney, and then she comes back and says, the outcome of that very well might be that she comes back to you and says, okay, I want to enroll now, a week later or something, after she's able to get that legal advice. Or she might say, to you, no, this is a priority to me, my status is questionable and who knows what's going to happen. He's eligible. I want him to enroll. And so just again to, let the person before you make the decision, and with your goal being to help them make an informed decision. So if they want more information, if they're seeking, if they have questions about the impact, to help connect them to the resources to get answers to those questions, and to empower them to make an informed decision.
One thing that I will say about, these referrals is that, when I've staffed these brief advice clinics, there generally is always someone who is eligible for some sort of status that they didn't know about. So that's, I think it's not a bad thing to consult with someone about this, because there's certainly going to be some people that don't have any form of immigration relief available to them at this moment, but there are going to be people who, didn't know about a U or T visa for victims of crimes and find out about it through doing an assessment through one of these legal service providers.
Great, thanks. So now we're going to open it up for your questions, and we have ample time, which is wonderful. So please, if you have questions, start typing them in the chat box, and we will do our best to answer them. If not now, if we can't answer them now, that we will get back to you.
So I had one question directed to me from Abby. If clients who need to consult with an immigration lawyer don't have the means to get one, or go to the organizations that you provided, do any of those organizations offer over-the-phone consults?
It's really going to depend on the organization, but a lot of them would have the capacity to do this over the phone. It's something where they generally wouldn't necessarily need to see the person in person. I think the exception would be the drop-in legal clinics. A lot of the drop-in legal clinics are only able to see people in person, but several of the other organizations could do phone consults. And that would be where, like Mariah said, forming a relationship with the referral agencies in your service area would be important, because then you would know things like that. And I also did want to point out a lot of the immigrant populations in our state are actually living on the border close to states like Minnesota or Illinois, and so it could be that their closest free or low-cost immigration legal services provider is actually in a different state, in Minnesota or Illinois. So at the bottom of the second page of the sheet, there is a link to the Immigration Advocates Network. They have a legal directory, and you can look up resources by state. So it could be that someone is living closer to organizations in Northern Illinois or in the Twin Cities area, and that's the best option for them.
So then I see that there's another question from Francie. Someone with a green card can apply for unemployment, or can someone with a green card apply for unemployment? It will affect his or her application to be a citizen in the future, or will it?
So someone who has their green card, we talked about that very limited ground of deportability, public charge ground of deportability, and that would not make someone deportable under the public charge ground of deportability. And public charge is not a determination when someone is filing for their citizenship or filing to naturalize.
And I guess to answer the first question, someone with a green card is eligible to apply for unemployment.
Thank you both. Okay, more questions. We will give you all a minute to mull over your questions and get them typed. I sincerely mean that. So this has been, there was a lot of information given, and we fully expect that you all might have questions down the line, and that is fine. If you have any type of question, even if you think it is silly, please ask it, because it means that probably at least 5 other people are thinking it. So very complex topic. So please ask. Do not be shy if you have a question. I'm going to do a little wrapping up now, but because it's only 11:27, you can keep typing your questions in as they come to you. So this is a live evaluation link, and we very much want and value your feedback. We know that things are likely to continue changing in this area, and so as a collaboration, we plan to continue to hold learning events, and we're committed to updating resources and materials on this. So your feedback is highly valuable. We will be planning another learning event, and the feedback you give today will help us make that better and more valuable to you all. So please share your open and honest feedback. Okay, we've got another question. So one individual is under DACA, married to a permanent resident, and they want to apply for CHIP, so the Child Health Insurance Program, for their citizen child. Is that possible? Would there be any repercussions?
Okay, so in that situation, we have someone who has DACA, who's married to a green card holder. They have a U.S. citizen child, and they're wondering if the child is eligible for CHIP, if that would impact the DACA holder's ability to get their green card. So if we go to the tool, do I need to talk to a lawyer? The relevant question is that first question. So I or someone in my family will have to use a U.S. consulate outside the U.S. to, and in this case, it would be apply for a green card or sponsor or co-sponsor an immigrant to get their green card. So really the important thing here is, when the permanent resident holder spouse petitions for the DACA holder spouse, is the DACA holder going to have to consular process from outside of the U.S., or is that person going to be able to adjust status from within the U.S.? So if the family doesn't know, if they say, well, I don't know, the DACA holder says, I don't know if I can adjust status from, within the U.S. or if I'm going to have to consular process, that would be a situation when you would provide them the referral list of attorneys. If the person says, I'm working with an attorney, I know I'm able to adjust status from within the United States, and they would say no to that question. And you would show them the answer no to all 3 questions box. So it really depends on whether the person consular processes, in which case they would contact an attorney and get some advice on that, or if they know they're able to adjust status, in which case they would say no to that question.
Thanks, Megan. So as you all continue to think about your questions, we want to let you know that the screening tool will continue to be changed and improved. And so if you have ideas, or even if it's just feedback, just like this was confusing or didn't work well, please let us know. You can email Stephanie Sievers at ssievers@wisconsin.edu. Stephanie did the lion's share of the work on this screening tool, and for that we are very thankful. And she is a master of receiving feedback and turning it and taking action. So please share your feedback. So we have another question, which is wonderful. Is it legal for immigration and customs enforcement agents to remove documents, including passports and IDs, of undocumented folks while in a detention center? Okay, so we've taken a sharp left.
Yes, and even if someone isn't detained, sometimes ICE will take hold of their passport.
Okay, we see that there's another question. We're going up. Okay, married couple. One is a U.S. citizen. Citizen is deceased. Other individual never became naturalized and no longer has valid green card. Is she eligible for BadgerCare Plus?
Well, first, I think the question is if she doesn't have a valid green card, does that make her undocumented?
Is this someone who, an undocumented person who is the widow of a U.S. citizen? I'm not.
So had a valid green card, but spouse is deceased, didn't naturalize, now green card is invalid.
When you don't, so if you, like, if someone gets their green card through a U.S. citizen spouse, like actually obtains their green card, and then the U.S. citizen spouse dies, that the green card holder spouse doesn't lose their status. There are special like petitions available for widows and widowers. You know, if someone never gained their green card status through marriage to a U.S. citizen.
So in that case, if their green card is still valid in a different circumstance or way to petition, then yes, they would still be eligible for BadgerCare, as long as their income was also in line and all of the other non-income related eligibility is in place.
And then you'd still go through that screening tool to see if they're sponsoring someone or traveling.
Did that answer your question? I think Kirk asked that question. And I see a comment, just because green card, great, Kirk. Just because green card is expired doesn't remove permanent residency status?
Right, yeah, and actually the old, every once in a while you'll see like a really old green card and they actually didn't even used to have expiration dates on them. So now they're generally good for like 10 years, and then it's definitely a very good idea to renew it and get your new card showing that you have lawful permanent resident status, especially these days.
Additional questions? Did we? Okay. Okay, so we'll keep going with the concluding remarks, but you can continue putting in questions if you have them. So I just wanted to thank you all for joining today. We know this is a complex topic, but we also know that people need information and want information, and that there's a lot of, you know, the rumor mill is definitely churning on this topic. And so we as a collaborative are committed to providing, you know, good information, clear information, and information that hopefully, because we come from a variety of perspectives, will make sense for enrollment assisters working at community health centers, working at hospitals, working at community agencies, helping people enroll in Marketplace, you know, kind of the full spectrum of enrollment assistance. As we shared before, we plan to host continued trainings on this topic as things change and as is needed. This was a pretty popular training. We had a lot of people sign up for it. An email went out this morning with some answers to some of the questions that we got in advance of the webinar. So questions that we didn't expect that would be answered by the information presented today, but that we wanted to try to get answers to, or try to get you answers to. So there was one specifically about public housing, and then there was one about what is the state of Wisconsin's plan in terms of disseminating information to the public on this topic. So you can look for answers to those two questions in your inbox. And we have another question. So could you please confirm if any immigrants are utilizing community health center sliding fee assistance is exempt?
So that really is going to depend on the answer to whether the person is going to have to consular process or not. So, you know, for adjusting status, like a sliding fee assistance is not something that is looked into when determining public charge. And it also is not included in the proposed rule for something that would be added. But if the person is consular processing or their relative is consular processing, that could be taken into account. So it really depends on that first question. You know, is the person, is consular processing involved?
Thanks, Megan. So I'll do one more plug for the evaluation and invite additional questions, since we are at 11:37 and we do have up until 12. This is ongoing work for us, and so we are working to get the materials that they will be available in Spanish as well as Hmong. Sorry, I sort of stumbled and stuttered over that, but we know that that is important, and that development is coming, so just stay tuned and check the website for updates. If someone has additional questions that they weren't able to put in the chat box today to get answered, you can send it to Caroline through she's going to type in her email address here, or the mechanism for submitting additional questions. And we will, as a group, work to address that question. And then, you know, just be on the lookout for additional information and trainings that we may be planning, that this collaborative will be planning. So, and if you have ideas or, you know, specific needs, like I have this group of people who really need to receive this information and we would like you to come present, or we want you to host a virtual webinar again, you know, let us know what those requests are. And we don't have unlimited resources to maybe fulfill everyone's request, but we will do our best. We are looking to, you know, present this information or new information based on any changes that come down the line at various learning events that are coming up in the summer and the fall. So I'll do one last call for any additional questions. We have a real live attorney here with expertise on immigration and public benefits, which is a rare treat. So if you have a question, please ask. And I will just open it up to any of my fellow presenters, any additional thoughts, comments, or insight that you want to share with this fantastic and committed group of enrollment assisters. So quiet. Okay. Well, we will conclude today's learning event then. Thank you all. Enjoy an additional 20 minutes.